In this module, we are going to talk about the death penalty. Currently, the United States is one of the few countries that still has the death penalty. As of December 2014, 98 countries had abolished the death penalty for all crimes, and 90% of all countries had banned the use of executions. As of the beginning of 2015, 32 states authorized the use of the death penalty, as does the United States federal government and the United States military. For example, the federal government is currently seeking the death penalty against the Boston Marathon suspect. Here's a breakdown of the states that currently have the death penalty versus those that don't. Notice that there are still a couple of states that have abolished the death penalty, but still have inmates on death row. As you can see, the number of executions in the United States has varied over time, with the highest number of executions occurring in 1999. In 2014, there were 35 executions in the United States, and so far in 2015, there have been 8 executions in the United States alone. I should note that this chart is specifically for executions in the United States since 1976. This is a breakdown by method in the United States, with the most frequent method being used as lethal injection, followed by electrocution, gas chamber, hanging, and firing squad. As you can see from this breakdown, the numbers of executions are definitely not evenly distributed across the country, and appears to be more heavily centered in the South, specifically Texas and Oklahoma. Constitutional challenges to the death penalty have been used or have been based on the Eighth Amendment's prohibition against cruel and unusual punishment, or the 14th Amendment's guarantee of equal protection under the law. In 1972, in the case of Furman v. Georgia, the Supreme Court ruled in a 5-4 decision that capital punishment, as then administered, was unconstitutional. However, the majority was deeply divided about why the death penalty should be considered unconstitutional. Each of the 5 justices in the majority wrote a separate opinion based on somewhat different reasoning. The points on which all 5 justices seemed to agree were that the penalty was, quote, wantonly and freakishly applied, end quote, and that there was no meaningful basis for distinguishing the few cases in which it is imposed from the many cases in which it is not, and that these problems were probably due to the uncontrolled discretion of judges or juries. The Furman decision did not rule out the use of the death penalty in principle. It only prohibited the way it was being carried out at the time. Following the Furman decision, many state legislatures redesigned their death penalty sentencing procedures to address the concerns of the court. Specifically, they tried to find ways of controlling the discretion of jurors in capital murder trials. In 1976, in Gregg v. Georgia and its companion cases, the Supreme Court rejected the idea of erasing all discretion by making death sentences mandatory for certain types of murder, but it approved a series of reforms designed to guide the discretion of jurors. Under these guided discretion statutes, defendants accused of capital murder are tried by juries in a 2-phase or bifurcated proceeding. Guilt is decided in the first phase. If the defendant is found guilty of capital murder, the sentence, either death by execution or life in prison without the possibility of parole, is decided in the second penalty phase. As a further check against the discretion of jurors, all death sentences are reviewed by state Supreme Courts. Executions resumed in 1977 when Gary Gilmore abandoned his appeals and was killed by a firing squad in Utah. At the end of the penalty phase of a capital trial, jurors are typically instructed to weigh those characteristics of the murder and the murderer that support a death sentence. These are called aggravating factors against those characteristics that support a sentence of life imprisonment are called mitigating factors. Aggravating factors increase the wrongfulness of the defendant's actions or the harmful impact of the crime. In contrast, mitigating factors reduce the defendant's blameworthiness and make execution less appropriate as a punishment, even though these factors do not justify or excuse the crime. Several cases decided by the Supreme Court since Gregg have focused on what jurors can and cannot consider as they attempt to weigh aggravating against mitigating factors. The court has held that jurors must be allowed to consider any aspect of a defendant's character or record and any circumstances of the offense that are offered as mitigation, and that jurors may determine the weight to be given to relevant mitigating evidence. However, jurors may not give it no weight by excluding such evidence from consideration. Jurors may also consider predictions about the defendant's future behavior and potential adjustment to prison, as well as how the death penalty of the victim, as well as how the death of the victim harmed his or her survivors. Since 2000, other decisions have placed further limits on death sentences. In 2002, in a 6-3 decision, the court put an end to the execution of mentally retarded prisoners in the case Atkins v. Virginia. Writing for the majority, John Paul Stevens argued that, quote, a national consensus has developed, end quote, against executing mentally retarded prisoners, and that, quote, because of their disabilities in areas of reasoning, judgment, and control of their impulses, they do not act with the level of moral culpability that characterizes the most serious adult criminal conduct, end quote. Less than a week later, in a 7-2 decision in Ring v. Arizona, the court held that it is unconstitutional for judges to decide whether a convicted murderer should be sentenced to death or life imprisonment. Only a jury can make that decision. Other decisions narrowed those eligible for executions and the type of crimes for which executions could be sought. In Roper v. Simmons in 2005, the court abolished the death penalty for all juvenile offenders. They based their ruling in part on psychological research indicating that key psychological capacities such as impulse control, rational decision-making, and long-term foresight are not yet fully developed in juveniles. The court reasoned that juvenile murderers should not be executed because they are inherently less culpable for their crimes. It was not until 2008 that the Supreme Court revisited the relationship between rape and the penalty for death. Although the High Court had prohibited capital punishment for the crime of rape more than 30 years earlier in Coker v. Georgia, it did not explicitly prohibit the death penalty for rapists of children. In 2008, 6 states still permitted execution as a penalty for child rape. In response to an attempt by the state of Louisiana to execute a man who had raped a child, the court ruled that unless the victim dies, the death penalty is not constitutional for rapists. This was in the case Kennedy v. Louisiana. Finally, in Bays v. Rees in 2008, the court held that the method of lethal injection does not, quote, inflict unnecessary or wanton pain, end quote, and therefore it does not violate the Eighth Amendment's ban on cruel and unusual punishment. Let's talk about some of the arguments for and against the death penalty. With regard to deterrence, one of the arguments for the death penalty is that the death penalty serves as a deterrent. Arguments state that society has always used punishment to discourage would-be criminals from unlawful action. Since society has the highest interest in preventing murder, it should use the strongest punishment available to deter murder, and that it is the death penalty. If murderers are sentenced to death and executed, potential murderers will think twice before killing for fear of losing their own life. For years, criminologists analyzed murder rates to see if they fluctuated with the likelihood of convicted murderers being executed, but the results were inconclusive. Then, in 1973, Isaac Ehrlich employed a new kind of analysis which produced results showing that for every inmate who was executed, 7 lives were spared because others were deterred from committing murder. Similar results have been produced by disciples of Ehrlich in follow-up studies. Moreover, even if some studies regarding deterrence are inconclusive, that is only because the death penalty is rarely used and takes years before an execution is actually carried out. Punishments which are swift and sure are the best deterrent. The fact that some states or countries which do not use the death penalty have lower murder rates than jurisdictions which do is not evidence of the failure of deterrence. States with high murder rates would have even higher rates if they did not use the death penalty. Arguments against the death penalty as a deterrent state that those who believe that deterrence justifies the execution of certain offenders bear the burden of proving that the death penalty is a deterrent. The overwhelming conclusion from years of deterrence studies is that the death penalty is, at best, no more of a deterrent than a sentence of life in prison. The Ehrlich studies have been widely discredited. In fact, some criminologists, such as William Bowers of Northeastern University, maintain that the death penalty has the opposite effect. That is, society is brutalized by the use of the death penalty, and this increases the likelihood of more murder. Even most supporters of the death penalty now place little or no weight on deterrence as a serious justification for its continued use. States in the United States that do not employ the death penalty generally have lower murder rates than states that do. The same is true in the U.S. as compared to countries similar to it. The U.S., with the death penalty, has a higher murder rate than the countries of Europe or Canada, which do not use the death penalty. The death penalty is not a deterrent because most people who commit murders either do not expect to be caught or do not carefully weigh the differences between a possible execution and life in prison before they act. Frequently, murders are committed in moments of passion or anger or by criminals who are substance abusers and acted impulsively. There is no conclusive proof that the death penalty acts as a better deterrent than the threat of life imprisonment. A survey of the former and present presidents of the country's top academic criminological societies found that 84% of these experts rejected the notion that research had demonstrated any deterrent effect from the death penalty. Once in prison, those serving life sentences often settle into a routine and are less of a threat to commit violence than other prisoners. Moreover, most states now have a sentence of life without parole. Prisoners who are given this sentence will never be released, thus the safety of society can be assured without using the death penalty. As for arguments about retribution, arguments that retribution is necessary state that when someone takes a life, the balance of justice is disturbed. Unless that balance is restored, society succumbs to a rule of violence. Only the taking of the murderer's life restores the balance and allows society to show convincingly that murder is an intolerable crime which will be punished in kind. Retribution has its basis in religious values, which have historically maintained that it is proper to take an eye for an eye and a life for a life. Although the victim and the victim's family cannot be restored to the status which preceded the murder, at least an execution brings closure to the murderer's crime. and closure to the ordeal for the victim's family, and ensures that the murderer will create no more victims. For the most cruel and heinous crimes, the ones for which the death penalty is applied, offenders deserve the worst punishment under our system of law, and that is the death penalty. Any lesser punishment would undermine the value society places on protecting lives. Robert Macy, District Attorney of Oklahoma City, described this concept of the need for retribution in one case. Quote, in 1991, a young mother was rendered helpless and made to watch as her baby was executed. The mother was then mutilated and killed. The killer should not lie in some prison with 3 meals a day, clean sheets, cable TV, family visits, and endless appeals. For justice to prevail, some killers just need to die. End quote. Arguments against the death penalty state that retribution is not necessary. Arguments state that retribution is another word for revenge. Although our first instinct may be to inflict immediate pain on someone who wrongs us, the standards of a mature society demand a more measured response. The emotional impulse for revenge is not a sufficient justification for invoking a system of capital punishment, with all its risks accompanying problems and risks. Our laws and criminal justice systems should lead us to higher principles that demonstrate a complete respect for life, even the life of a murderer. Encouraging or basing our motives of revenge, which ends in another killing, extends the chain of violence. Allowing executions sanctions killing as a form of payback. Many victims' families denounce the use of the death penalty. Using an execution to try to right the wrong of their loss is an affront to them and only causes more pain. For example, Bud Welch's daughter, Julie, was killed in the Oklahoma City bombing in 1995. Although his first reaction was to wish that those who committed this terrible crime would be killed, he ultimately realized that such killing, quote, is simply vengeance, and it was vengeance that killed Julie. Vengeance is a strong and natural emotion, but it has no place in our justice system, end quote. The notion of an eye for an eye, or a life for a life, is a simplistic one, which our society has never endorsed. We do not allow torturing the torturer or raping the rapist. Taking the life of a murderer is a simply disproportionate punishment, especially in light of the fact that the U.S. executes only a small percentage of those convicted of murder. And these defendants are typically not the worst offenders, but merely the ones with the fewest resources to defend themselves. With regards to innocence, arguments for the death penalty state that the necessity of using the death penalty outweighs the risk of executing an innocent person. Arguments state that there is no proof that any innocent person has actually been executed since increased safeguards and appeals were added to our death penalty system in the 1970s. Even if such executions have occurred, they are very rare. Imprisoning innocent people is also wrong, but we cannot empty the prisons because of that minimal risk. If improvements are needed in the system of representation or in the use of scientific evidence such as DNA testing, then those reforms should be instituted. However, the need for reform is not a reason to abolish the death penalty. Besides, many of the claims of innocence by those who have been released from death row are actually based on legal technicalities. Just because someone's conviction is overturned years later and the prosecutor decides not to retry him does not mean he is actually innocent. If it can be shown that someone is innocent, surely a governor would grant clemency and spare the person. Hypothetical claims of innocence are usually just delaying tactics to put off the execution as long as possible. Given our thorough system of appeals through numerous state and federal courts, the execution of an innocent individual today is almost impossible. Even the theoretical execution of an innocent person can be justified because the death penalty saves lives by deterring other killings. Arguments against the death penalty state that the death penalty should not be used because innocent people may be executed. They state the death penalty alone imposes an irrevocable sentence. Once an inmate is executed, nothing can be done to make amends if a mistake has been made. There is considerable evidence that many mistakes have been made in sentencing people to death. Since 1973, at least 114 people have been released from death row after evidence of their innocence emerged. During the same period of time, over 900 people have been executed. Thus, for every 9 people executed, we have found one person on death row who never should have been convicted. These statistics represent an intolerable risk of executing the innocent. If an automobile manufacturer operated with similar failure rates, it would run out of business. Our capital punishment system is unreliable. A recent study by Columbia University Law School found that 2/3 of all capital trials contained serious errors. When the cases were retried, over 80% of the defendants were not sentenced to death, and 7% were completely acquitted. Many of the releases of innocent defendants from death row came about as a result of factors outside of the justice system. Recently, journalism students in Illinois were assigned to investigate the case of a man who was scheduled to be executed after the system of appeals had rejected his legal claims. The students discovered that one witness had lied at the original trial, and they were able to find the true killer, who confessed to the crime on videotape. The innocent man who was released was very fortunate, but he was spared because of the informal efforts of concerned citizens, not because of the justice system. In other cases, DNA testing has exonerated death row inmates. Here, too, the justice system had concluded that these defendants were guilty and deserving of the death penalty. DNA testing became available only in the early 1990s, due to advancements in science. If this testing had not been discovered until 10 years later, many of these inmates would have been executed. And if DNA testing had been applied to earlier cases where inmates were executed in the 70s and 80s, the odds are high that it would have been proven that some of them were innocent as well. Society takes risks in which innocent lives can be lost. We build bridges, knowing that statistically some workers will be killed during construction. We take great precautions to reduce the number of unintended fatalities. But wrongful executions are a preventable risk. By substituting a sentence of life without parole, we meet society's needs of punishment and protection without running the risk of erroneous and irrevocable punishment. With regard to arbitrariness and discrimination, arguments for the death penalty state that the death penalty is neither arbitrary or discriminatory. They state that discretion has always been an essential part of our system of justice. No one expects the prosecutor to pursue every possible offense or punishment, nor do we expect the same sentence to be imposed just because 2 crimes appear similar. Each crime is unique, both because the circumstances of each victim are different and because each defendant is different. The U.S. Supreme Court has held that a mandatory death penalty, which applied to everyone convicted of first-degree murder, would be unconstitutional. Hence, we must give prosecutors and juries some discretion. In fact, more white people are executed in this country than black people. And even if blacks are disproportionately represented on death row, proportionately, blacks commit more murders than whites. Moreover, the Supreme Court has rejected the use of statistical studies which claim racial bias as the sole reason for overturning a death sentence. Even if the death penalty punishes some while sparing others, it does not follow that everyone should be spared. The guilty should still be punished appropriately, even if some do escape proper punishment unfairly. The death penalty should apply to killers of black people as well as to killers of whites. High-paid, skillful lawyers should not be able to get some defendants off on technicalities. The existence of some systemic problems is no reason to abandon the whole death penalty system. Arguments against the death penalty state that the death penalty is used arbitrarily. They state that in practice, the death penalty does not single out the worst offenders. Rather, it selects an arbitrary group based on such irrational factors as the quality of the defense counsel, the county in which the crime was committed, or the race of the defendant or victim. Almost all defendants facing the death penalty cannot afford their own attorney. Hence, they are dependent on the quality of the lawyers assigned by the state, many of whom lack experience in capital cases or are so underpaid that they fail to investigate the case properly. A poorly represented defendant is much more likely to be convicted and given a death sentence. With respect to race, studies have repeatedly shown that a death sentence is far more likely where a white person is murdered than where a black person is murdered. The death penalty is racially divisive because it appears to count white lives as more valuable than black lives. Since the death penalty was reinstated in 1976, 158 black defendants have been executed for the murder of a white victim, while only 11 white defendants have been executed for the murder of a black victim. Such racial disparities have existed over the history of the death penalty and appear to be largely intractable. It is arbitrary when someone in one county or state receives the death penalty, but someone who commits a comparable crime in another county or state is given a life sentence. Prosecutors have enormous discretion about when to seek the death penalty and when to settle for a plea bargain. Often those who can only afford a minimal defense are selected for the death penalty, while race and other arbitrary factors like economics and geography are a determinant of who lives and who dies, which means that the death penalty must not be used. With regard to cost, some of the arguments for the death penalty state that we could greatly reduce the cost of the death penalty if we limited the excessive appeals process. They state that the death penalty is only more expensive than life without the possibility of parole because the appeals process drags on for 10, 15, and sometimes 20 years. Defense attorneys are constantly trying to find some small technicality that will allow their client to have a new trial. These appeals are unnecessary and are a drain on state and county resources. Death row inmates should be limited to one automatic appeal. They should not be allowed to appeal the same issues over and over again until they can find a judge who agrees with them. The system already has many checks and balances. These checks and balances help prevent wrongful conviction and allow the process to move forward. If the courts fail to address an error, the governor can prevent the execution from going forward until the issue is addressed. There are many safeguards built into the system. Excessive appeals simply keep the system from working efficiently. Once the defendant's guilt is determined, he or she should not be able to manipulate the system endlessly. If death row inmates were executed after a few years instead of 10 or 20 years, in addition to saving money on legal fees, the state would not have to pay to house and feed the inmates for years and years. This would decrease overcrowding in our prisons and reduce the total operational cost of the prison. The death penalty is less expensive than life without the possibility of parole when it is implemented in a swift and efficient manner. Arguments against the death penalty based on costs state the death penalty is too expensive and takes resources away from other important issues like education. They state death penalty cases are much more expensive than other criminal cases and cost more than imprisonment for life without parole. In California, capital trials are 6 times more costly than other murder trials. A study in Kansas indicated that a capital trial cost almost $120,000 more than an ordinary murder trial. Complex pretrial motions, lengthy jury selections, and expenses for expert witnesses are all likely to add to the costs in death penalty cases. The irreversibility of the death sentence requires courts to follow heightened due process in the preparation and course of the trial. The separate sentencing phase of the trial can take even longer than the guilt or innocence phase of the trial. And defendants are much more likely to insist on a trial when they are facing a possible death sentence. After conviction, there are constitutionally mandated appeals which involve both prosecution and defense costs. Most of these costs occur in every case for which capital punishment is sought, regardless of the outcome. Thus, the true cost of the death penalty includes all the added expenses of the unsuccessful trials in which the death penalty is sought but not achieved. Moreover, if a defendant is convicted but not given the death sentence, the state will still incur the costs of life imprisonment, in addition to the increased trial expenses. For the states which employ the death penalty, this luxury comes at a high price. In Texas, the death penalty case costs taxpayers an average of $2.3 million, about 3 times the cost of imprisoning someone in a single cell at the highest security level for 40 years. If the death penalty was abolished, the state could direct more funds into education, after-school programs, job training centers, community safety programs, or drug and alcohol rehabilitation programs. In addition to the bifurcated structure of death penalty trials, there is another unique aspect of capital trials, the process of death qualification. During voir dire, potential jurors in capital murder cases are asked about their willingness to vote for the death penalty if the defendant is found guilty. In 1985, in the case of Wainwright v. Witt, the Supreme Court ruled that potential jurors whose beliefs substantially impair their ability to consider or impose a death sentence must be excused from serving on a capital jury. If a potential juror expresses a lack of willingness to seriously consider execution as a punishment, he or she is not permitted to serve on a capital jury. This typically means that between 30% and 40% of potential jurors are excluded from serving on capital juries. Those excluded potential jurors are more likely to be female, African American, and politically liberal. Research shows that death qualification affects both who gets on the jury and the attitudes of jurors towards the defendant. Compared to jurors who are screened out by the process, death qualified jurors are more likely to vote to convict the defendant. Death qualified jurors are not only more conviction prone when deciding guilt, they tend to be more receptive to aggravating factors and less receptive to mitigating factors during the penalty phase. A second, more subtle effect occurs because juries try to make sense of the odd process of death qualification. Jurors who answer a series of questions about their willingness to vote for a death sentence during the selection process often infer that both defense attorneys and prosecutors anticipate a conviction and a death sentence. Why else would they be asking about a death sentence before the trial even begins? This effect works against the defendant. In the 1986 case of Lockhart v. McCree, the Supreme Court reviewed the research on death qualification, then dismissed it as irrelevant. In the majority decision, Justice Rehnquist wrote, quote, "We will assume for purposes of this opinion that the studies are both methodologically valid and adequate to establish that death qualification in fact produces juries somewhat more conviction prone than non-death qualified juries. We hold, nonetheless, that the Constitution does not prohibit the states from death qualifying juries in capital cases." End quote. Although the Supreme Court did not view the research as important, many prosecutors appear to understand the biasing effects of the death qualification process. For example, in the Andrea Yates trial, some legal scholars have argued that the prosecutor's motivation for charging Miss Yates with capital murder was to assemble a jury that was more likely to convict her on the murder charges. Indeed, once Yates was convicted, prosecutors did not vigorously pursue a death sentence during the penalty phase. In his penalty phase summation, the prosecutor appeared to argue against execution. If you want to sentence her to life rather than death sentence, you will have done the right thing. Apparently, the goal was to use the death qualification process to, quote, get a pro-prosecution jury, one more likely to reject the insanity defense and return a verdict of guilt, end quote. The penalty phase of a capital murder trial is qualitatively different from other criminal proceedings. The question posed to jurors is not, did the defendant commit the crime, but should the defendant be killed in the execution chamber? That question cannot be answered by examining the facts of the case or applying rules of logic. To help jurors make this life or death decision, judges instruct jurors to weigh aggravating factors against mitigating factors. Unfortunately, those instructions appear to provide little help. Research using both trial simulations and post-verdict interviews with actual jurors demonstrate that jurors misunderstand the penalty phase instructions. For example, many jurors wrongly believe that they cannot take into account the full range of mitigating factors, or that if they find any aggravating factors to be present, they must vote for death. Many jurors also mistakenly believe that unless they vote for death, the murderer will be eligible for parole. The meaning of the key terms aggravating factors and mitigating factors are unclear to jurors, and jurors are unclear about how to weigh the two sets of factors. Here is a quote from a juror who was interviewed after serving on a capital murder trial. The different verdicts that we could come up with depend on if mitigating outweighed aggravating, or if aggravating outweighed mitigating, or all of that. So we wanted to make sure. I said, I don't know that I exactly understand what it means. And then everybody else said, no, neither do I, or I can't give you a definition. So we decided to ask the judge. Well, the judge wrote back and said, you have to glean it from the instructions. End quote. If jurors are not able to rely on the court to clarify the nature of their task, they must rely on their own rough translations of the meaning of penalty phase instructions. Here is how a different juror put it. Quote, all that becomes very foggy and gray and just sort of burns off in the sun. Did he do it? Yeah. Did he mean it? Yeah. That's what the people on the jury broke it down to. End quote. If instructions to jurors are difficult to understand, jurors may fall back on their own preconceptions or prejudices. In an experimental test on the proposition, 397 mock jurors watched a realistic videotaped simulation of a capital penalty trial for a defendant who had been found guilty of robbery and murder. The content of the videotape and the jury instructions were held constant for all mock jurors, but the race of the defendant and the race of the victim were varied. There were 4 conditions: white defendant, black victim, white defendant, white victim, black defendant, black victim, and black defendant, white victim. The findings revealed that both race and comprehension of instructions had an impact on sentencing. In the condition where the defendant was white and the victim was black, 40% of mock jurors handed down a death sentence. But in the condition where the defendant was black and the victim was white, 54% of mock jurors recommended a sentence of death. Perhaps more important, the researchers found an interaction between comprehension of instructions and race of defendant. Among jurors who understood the instructions well, the rate of death sentences did not differ as a function of race. However, among jurors with poor comprehension of instructions, the rate of death sentences for the white defendants was 41%, while the rate for black defendants was 60%. To test the effects of instructions on death sentencing, other researchers looked at the interaction between defendant race, black or white, and type of jury instructions, standard or simplified. The clearer, simplified instructions led to better comprehension and significantly reduced the bias against black defendants. These findings suggest that if the instructions given to jurors failed to provide jurors with clear, comprehensible guidance about how to make the life or death decision, racial bias may creep up in the decision-making process. Prior to the Civil War, the behavior of blacks in the South was regulated by a set of laws called the Black Codes. Blacks could be executed for theft, but whites could pay a fine. The rape of a black woman was not considered a crime, but many black men were executed for allegedly raping white women. Although blacks and whites later became equal under the law, discrimination persisted. Racial discrimination in the application of the death penalty continued and was especially conspicuous in cases of rape. Between 1930 and 1967, 455 men were executed for the crime of rape. Of those men, 89% were black. In 1973, researchers analyzed 361 rape convictions. After statistically controlling for many other variables, the researchers found that the best predictor of a death sentence was the race of the offender combined with the race of the victim. Black men convicted of raping white women were 18 times more likely to be sentenced to death than any other racial combination. Use of the death penalty for the crime of rape was examined in the 1997 case of Coker v. Georgia. In that case, the Supreme Court held that the death penalty was disproportionately severe for the crime of rape. Surprisingly, the shocking racial disparities in the imposition of the death penalty for rape was not an explicit factor in the court's decision. However, it may have been that research on racial disparity had an influence behind the scenes. Although evidence of racial discrimination is clearest for cases involving rape, discrimination has not been limited to the crime of rape. Several analyses of death penalty cases indicate that race has an impact at several stages in the legal process. Following arrest, black defendants are more likely than white defendants to be charged with capital murder, and once charged, they are more likely to be convicted. Following conviction, blacks are more likely to be sentenced to death, and once sentenced, they are more likely to be executed. The race of the victim is especially important. If the victim is white, prosecutors are more than twice as likely to seek a death sentence than if the victim is black. And blacks who kill whites are about 4 times more likely to be charged with capital murder than blacks who kill blacks. In a sophisticated analysis of race and the death penalty, David Baldus, George Woodworth, and Charles Pulaski in 1990 found that even after taking over 20 relevant variables into account, prosecutors decided to seek the death penalty 5 times more often against killers of whites than against killers of blacks. In addition, Baldus and his colleagues analyzed 594 homicides in Georgia. They found that blacks convicted of killing whites were sentenced to death in 22% of capital cases, while whites convicted of killing blacks received a death sentence only 3% of the time. Looking more deeply at their data, the researchers took into account more than 250 characteristics of the murder, the offender, and the victim. Even after removing the influence of all of these variables, the odds of receiving a death sentence were 4.3 times higher for murderers of whites than for murderers of blacks. These findings were presented to the Supreme Court in the case of McCleskey v. Kemp in 1987. In the view of many social scientists, the majority of the court, as it was a 5-4 decision, was frustratingly unreceptive to the evidence. Although the justices were unable to offer any explanation for the striking racial disparities, they were unwilling to accept the research findings. The majority decision in McCleskey, written by Justice Powell, held that some unfairness is tolerable and inevitable because discretion is an inescapable aspect of capital sentencing. In addition, the court held that any discrimination in McCleskey's case was not intentional and the defendant's attorney had failed to present evidence specific to his own case that would support an inference that racial consideration played a part in his sentence. Put differently, to overturn a death sentence because of racial bias, there would need to be strong evidence that jurors acted with discriminatory purpose. Some scholars have pointed out that this standard of proof is higher than the legal standard needed to demonstrate discrimination in housing or employment. Consequently, a person denied housing or employment has more protection from racial discrimination than a person whose life is at stake. More recent analyses of both state and federal court decisions indicate that discrimination in death sentences, particularly by race of victim, persists. Blacks and whites are about equally likely to become the victims of aggravated murder, the kind that is punishable by death. However, a black murderer whose victim is white is 6 times more likely to receive a death sentence than a white murderer whose victim is black. Race makes a difference even after a defendant has been sentenced to death. Most inmates on death row die before being sent to the execution chamber. But black death row inmates convicted of killing white victims have the highest probability of actually being executed. Here are some of the most recent studies on race. Jurors in Washington state are 3 times more likely to recommend a death sentence for a black defendant than for a white defendant in a similar case. In Louisiana, the odds of a death sentence were 97% higher for those for whose victim was white than for those whose victim was black. A study in California found that those who killed whites were over 3 times more likely to be sentenced to death than those who killed blacks, and over 4 times more likely than those who killed Latinos. A comprehensive study of the death penalty in North Carolina found that the odds of receiving a death sentence rose by 3.5 times among those defendants whose victims were white. And in 96% of states where there have been reviews of race and the death penalty, there was a pattern of either race of victim or race of defendant discrimination, or both. With regard to the race of defendants executed, the most current numbers break down as follows. White defendants equal about 780, or 55%. Black defendants are about 486, or 35%. Hispanic equal about 112, or 8%, and other includes about 24 defendants, or 2%. As for the race of the victims in death penalty cases, over 75% of the murder victims in cases resulting in an execution were white. It is important to note that the national average is 50% of murder victims generally are white. As you can see from these two charts, there is a little bit of a discrepancy here. We discussed the death penalty as a deterrent a little bit earlier, but let's dive deeper into this subject. Largely because of a belief in deterrence, early forms of execution were gruesome, slow, and public. It was thought that more terrifying executions would be more powerful deterrents, and if more people watched, more potential criminals would be deterred. Executions were festive public events. In Germany, prior to the 1700s, huge crowds gathered to watch criminals be broken at the wheel. On a raised stage, criminals would be tied to a large wagon wheel. The executioner would methodically smash the bones of the legs and arms with a steel bar before bringing death by a blow to the throat. To deter crime in England, criminals were disemboweled and decapitated after being strangled in a public ceremony. The heads of executed criminals were displayed at crossroads and on London Bridge to serve as a visible warning to potential wrongdoers. The proposition that capital punishment deters homicide can be tested. If the death penalty does deter murder, states with the death penalty should have relatively low murder rates. To test this hypothesis, researchers have compared the murder rates in no death penalty states to murder rates in similar, geographically adjacent death penalty states, such as Michigan is compared to Ohio, Rhode Island to Connecticut, North Dakota to South Dakota. Findings indicate that, overall, states with the death penalty have significantly higher rates than states without it. A second hypothesis, derived from deterrence theory, is that murder rates should rise or fall when death penalty laws change. This hypothesis can be tested by closely examining murder rates over time. Specifically, deterrence theory predicts that if a state abolishes the death penalty or suspends it for a period of time, the murder rate will rise because the deterrent is no longer in effect. Conversely, if a state establishes the death penalty or reinstates it after a period of absence, murder rates should fall because the deterrent is now in effect. Like the first hypothesis, this second hypothesis has not been supported by the data. Multiple studies conducted in the United States and 12 other countries provide no evidence that capital punishment suppresses the murder rate. When comparing adjacent states or measuring changes in murder rates over time, most studies have used statistical procedures that remove the influence of other factors known to affect rates of violence, such as unemployment, number of young men in the population, and the size of the police force. In addition, some studies have looked only at the specific types of murder punishable by death, for example, killing of a police officer. Finally, many studies have looked at the effects of each actual execution rather than the effect of simply having the death penalty on the books. Despite many decades of research by a variety of researchers using a variety of methods, there is still no credible evidence that the death penalty deters murderers. Indeed, a few researchers have come to the opposite conclusion, that executions increase murder rates. An analysis of data from nearly 70 studies found that executions usually stimulate a small increase in murders, 1 to 4 murders, in the weeks following an execution. Careful examinations of more than 60 years of data on the death penalty and murder rates have revealed this same effect. This brutalization effect is stronger for highly publicized executions. Like other forms of violence in the media, executions may weaken inhibitions against violent behavior, desensitize people to killing, and communicate the message that killing is a justifiable response to provocation. Deterrence is a theory about psychological processes in the mind of the murderer. It posits that potential murderers will be restrained by the knowledge that they might be executed if they act on their desire to kill. That is, their fear of execution will stop them from killing. There are several problems with this theory. First, there is no evidence that people engage in a rational weighing of costs and benefits before committing a murder. In fact, most murders are crimes of passion, the product of rage, jealousy, hatred, or fear. In addition, the murderer is often under the influence of drugs or alcohol. Second, most murderers believe that they will not be put to death, and they are right. As noted earlier, the probability that they will be executed is very low. Of course, many murderers believe that they will not even be caught, or that if they are caught, they will not be convicted or sentenced to death. Third, it is not clear whether the prospect of being executed elicits more or less fear than the prospect of life in prison without parole. Life in prison without hope of release may be no less frightening than the remote possibility of being executed sometime in the distant future. Here is some of the most current research on deterrence. A report by the National Research Council stated that studies claiming that the death penalty has a deterrent effect on murder rates are fundamentally flawed and should not be used when making policy decisions. Consistent with previous years, the 2013 FBI crime report showed that the South had the highest murder rate, and the South accounts for over 80% of executions. The Northeast, which has less than 1% of all executions, had the lowest murder rate. According to a new survey of the former and present presidents of the country's top academic societies, 88% of those experts rejected the notion as well. Here are some of the most current research on cost. So defense costs for death penalty trials in Kansas averaged about $400,000 per case compared to the $100,000 per case when the death penalty was not sought. A study in California revealed that the cost of the death penalty in the state was over $4 billion since 1978. In Maryland, an average death penalty case resulting in a death sentence cost approximately $3 million. And the eventual cost to the taxpayers between 1978 and 1999 was about $186 million. And that was only for 5 executions. Enforcing the death penalty costs Florida $51 million a year, above what it would cost to punish all first-degree murderers with life in prison without parole. Based on the 44 executions between 1976 and 2000, that amounted to about $24 million for each execution. The most comprehensive study in the country found that the death penalty cost North Carolina $2.16 million per execution over the costs of sentencing murderers to life imprisonment. And the majority of those costs occurred at the trial level, not the appeals process. In Texas, a death penalty case costs an average of $2.3 million, about 3 times the cost of imprisoning someone in a single cell at the highest security level for 40 years. One way of gauging the effectiveness of our system of capital punishment is to analyze how many death verdicts are overturned and why they are overturned. In a massive study of how cases move through the legal system, researchers examined every capital case in the United States from 1973 through 1995. They found that 68% of death sentences were reversed because of serious errors at trial. When these reversed cases were retried, 82% of the defendants were given a punishment less than death, and 7% of the defendants were found not guilty of the crime that had sent them to death row. The most frequent causes of error included incompetent defense lawyers, which was 37% of cases, faulty or misleading jury instructions, which was 20% of cases, and various forms of prosecutorial misconduct, such as suppression of evidence or intimidation of the witnesses, which was about 19% of cases. Although 7% of death row inmates were later found to be not guilty, the study does not tell us how many innocent people were actually executed. Once an inmate is executed, all appeals cease. The most troubling form of error in capital cases is the wrongful conviction, imprisonment, and execution of an innocent person. In their landmark study of wrongful convictions since 1900, Hugo Bedeau and Michael Radlett identified 416 people who were wrongfully convicted of murder and sentenced to death. In 23 of those cases, their analysis suggests that the innocent person was executed. What makes these wrongful convictions especially disturbing is that most were caused by factors that are difficult for the legal system to detect. The main causes for these miscarriages of justice were police error, such as coerced or false confessions, sloppy or corrupt investigation, prosecutor error, which was suppression of exculpatory evidence, witness error, which was mistaken eyewitness identification or a perjured testimony, as well as other various factors such as misleading circumstantial evidence, forensic science errors, incompetent defense lawyers, exculpatory evidence that is ruled inadmissible, insufficient attention to all alibis, and pressure created by community outrage. Perhaps the most important recent development in the death penalty has been the use of DNA evidence to prove the innocence of people on death row. More than 140 people have been released from death row because of exonerating evidence. In several of these cases, some form of biological trace evidence, such as skin under the fingernails of a victim, or a semen stain on the panties of the victim, was used to identify the real murderer and to exclude the wrongfully convicted person. Although it is essential for prisoners on death row to have access to DNA testing that may exonerate them, DNA is only useful in a minority of murder cases. To make use of DNA testing to prove guilt or innocence, biological evidence must be available. In most murder cases, biological evidence does not exist. Either none was left at the scene, or none was properly collected at the scene, or if it was collected, it was not preserved by police. As recently as 2002, the Los Angeles Police Department destroyed biological evidence in more than 1,100 cases involving rape. Some of these cases involved prisoners on death row who had been convicted of murder during the commission of a rape. In the case that probably ended in the execution of an innocent man, no biological evidence was admissible. Gary Graham was convicted of shooting a man in a grocery store parking lot during a holdup. The sole evidence against him was the eyewitness testimony of a woman who claimed to have seen Graham through her windshield from across the parking lot. Two other eyewitnesses who were willing to testify that Graham was not the killer were never called to testify at trial. Later, after viewing videotaped testimony from these two uncalled witnesses, 3 jurors in the case signed affidavits saying that they would have acquitted Graham if they had been allowed to hear from these 2 other witnesses at trial. The Texas Board of Pardons found this evidence unpersuasive. In June of 2000, a team of prison guards escorted Gary Graham to the execution chamber and strapped him to the lethal injection gurney. He proclaimed his innocence to the very end. These are some examples of how executions can go wrong. In a 2010 poll by Lake Research Partners, they found that a clear majority of voters, about 61%, would choose a punishment other